This week on Lewis on the Law, I have yet another awesome show for you. I have attorney Lacey Bell in with me, and we're going to talk contracts for entrepreneurs and startups.
Welcome to Lewis on the Law.
You are listening to Lewis on the Law, and I have yet another empowering show for you, the listener. We're here on Biz 1190, and so we're going to talk a little business today. I have attorney Lacey Bell on with me, and we're going to talk contract issues for startups and entrepreneurs. Now, Lacey, tell me a little bit about your law firm.
Yeah, so my law firm is LB Legal and Consulting Firm. I do mostly business law and some IP issues. Yeah, so it's pretty new for me, but it's something I'm passionate about, and I'm excited about helping people start their businesses and, and accomplish those goals.
That is really exciting. I mean, I think it always gives you like a feeling of fulfillment to actually help someone like really get started and get going.
Exactly. It's like it's a different type of motivation that, I haven't found anywhere else.
Yeah, and working for yourself, being your own boss, it can be extremely empowering. It can also have its moments of difficulty too.
Yeah, it definitely has some moments of difficulties, but overall, like you said, it's super empowering and it feels good to do. So it comes, it makes all of the difficult times that much,
better.
Yeah, easier
exactly.
to handle.
Yeah, victories are much sweeter.
Exactly.
So why are contracts important?
So contracts are important because...
I guess that's a silly question. I'm an attorney. I'm like, why are contracts important?
Yeah, but people don't, know. A lot of business owners and startups that come to me, they usually come to me when there's an issue on a deal or an issue with a service they're providing, and they say, hey, I haven't been compensated. I've been doing this work for providing this service for these people for this amount of time. And I'm like, oh, well, let me look at the contract that you guys have. And usually what I find is, oh, we don't have a contract. Mm-hmm. And that's the biggest problem. Like a lot of business owners go into as far as like starting their businesses and then not having those appropriate contracts.
Mm-hmm.
To then
what, a handshake doesn't work? A handshake hey, let's do business doesn't you spit on your palm and you shake hands. I guess you don't spit on your palms much, huh?
Yeah, I would not advise doing that. But I also obviously don't advise doing the handshake agreements anymore, right? Because you just never know when people's circumstances will change and when, for whatever reason, deals go bad or people change their mind about what they feel is fair payment. And so it's better to have those things up front in writing in a contract about how you're going to be paid and the terms and when you're going to get paid and what you're providing, what performance you're giving, so that nobody can change their mind. We have it right here in black and white. We all agree to, do it this way. So, and you'll have legal recourse when something goes awry, like when somebody is not making their payments or not performing under a contract. You have something to go to court on, and other than a handshake, because that doesn't work. It's like, then it becomes your word against the other person's word.
Yeah, because you can have failure of conditions, you can have terms that are all messed up.
Exactly.
Statute of frauds, all kinds of
you get into all those contract issues, and I have to explain that to them. Well, like, but this person gave me their word. We had an agreement, and I'm like, you got to have it, in a contract.
We shook hands. We ate steak dinner. We drank a couple of bottles of wine. Everything was great.
I know this person. I trusted them. You can't go on trust. You got to treat contracts, and I always say like a relationship, you should trust the person you're working with, but at the end of the day, we've seen tons of like other cases, like, and we're going to get to later on, like with Facebook and even the Beats headphones lawsuit, where partners and even like co-founders end up at the end of the day going at each other because something doesn't span out well for one partner. They feel like another partner is getting an advantage that they don't have.
Yeah, I love that. So we're going to talk about some cases later on.
Yes,
that
definitely.
Is awesome. So what are the dangers of not having a well-defined contract?
So if you don't have a well-defined contract, as I previously stated, you can fall into situations where there's ambiguity between what you thought was the way we were going to do things. Say you and I entered a contract. And there's a famous like case law in law school that we all learned about the ship and what time it's supposed to like reach the dock or whatever. So I might have said 3 o'clock, and you might interpret that as 3 o'clock p.m., and I might have thought it was 3 a.m.
Mm-hmm.
So that's one issue, that if it's not well defined, if you haven't like lined out and specified every single thing in that contract down to like what time of the day and what, like I just said, then you could have those issues of someone thinking that it means this and another person thinking it means something completely different.
Yeah, because then you have the whole issues about performance, about what am I supposed to actually do?
Exactly.
When do I do it? What are the terms?
Exactly. And how do I do it? Like, was I supposed to deliver it by mail? Was I supposed to deliver it by email? Like, is it okay that when I put it in writing, is that sufficient if I just write you a text?
Mm-hmm.
Or should I have gotten a letter, and mailed it to your establishment?
Yeah. So are there no situations in which oral contracts work anymore? I mean, is it just not a thing?
It's really not. I want to say, they could work by law. Sometimes you can enter an oral contract and it can work. But once you enter like the business world and you have your own company, you can't rely on oral contracts. I haven't seen one being upheld, with a big business or a big company or even a smaller companies.
Yeah. Because
you should have those contracts in place.
So what about the poorly drafted contracts? Because I mean, I see this every now and then. I do primarily real estate, so I've had a couple of past issues, and I shouldn't discuss past cases, but I've seen some poorly drafted contracts between people just in a partnership agreement.
So people should be very, very careful with those type of contracts, and I think a lot of people try and like take a side way of coming to a lawyer. Instead of going to a lawyer, they're like, oh, I could just find this form online, and they pull up, partnership agreement or operating agreement.
They can like write it down on a piece of paper and just kind of write out their contract
themselves. That's right.
I've actually
seen that?
I've had a case where I got into a litigation dispute between partners who had just like written down stuff.
And that's why you need an attorney, right? Like, because people don't understand, to be enforceable by law, there's certain things a contract has to have. It has to have like acceptance. It has to be offer acceptance. And obviously the terms have to be what the parties intended. Mm-hmm. So you can't just jot down certain information on a piece of paper, because
you can't.
You cannot
do that. Or are you going to pay someone like me or you to duke it out in court?
You should probably do that. You would come out on the better side of that if you did it that way.
So what kind of legal recourse does a person have on these handshake deals? I mean, say you made a handshake deal. Is there any? Do you have any hope?
There is some hope. I mean, you're not completely lost if you made a handshake deal. I think you could still go to court, and like I said before, it would be your word against the other person's word, and then a judge would probably look at like how you normally handle these issues if you have a relationship with that person, if you did business on other instances with them, and and they would look at what we would call parole evidence if it was a contract.
Now, parole evidence, you used a fancy term there. What does that mean?
Parole evidence is that
evidence I got out of jail and now I got to report to the guy?
And that's what it sounds like, right?
Parole, yeah.
That's definitely what it sounds like. So no, it's actually the parole evidence rule is when you're allowed to look at things outside of the boundaries of the contract, of the writing and agreement. You can look at how the parties, like I said before, performed in past, and how, they interacted. I mean, you could probably even look at like email correspondence, because some person can say, oh, well, we decided to alter our contract, or we amended it, but we did it only, verbally, or we did it only via email. I said it was okay for him to do it this way, even though our contract says, we would do it this way. So sometimes in cases like that, you can look outside the corners of the contract to figure out, what is really going on here.
I love the email chains and trying to get that in as evidence.
But they do come in. They do come in, especially like in the court cases, like IMs, anything is up for grabs. So you should always be mindful. That's another thing. You should be mindful when you're writing IMs and business owners what you're saying, because if you
go paper trail,
exactly, because if you ever go to court on it, all of that is up for discovery.
I've used the paper trail on demand lead notices. Do you remember when you said you were going to give him this much money back, and it's all here in these emails?
There you go, and that's why you can use that. So if you don't have an agreement and you have those things, it's like, well, here, this is just as good as like our agreement or having an agreement.
Yeah. So we are at the end of this segment, Lacey. So give them some contact information for you real
so
quickly.
I can be reached at LB Legal Consulting Firm, of course, at 678-824-4239. Also, my website is lblegalconsulting.com. And, of course, my email is abel@lblegalconsulting.com.
You are listening to Lewis on the Law. My name is James Lewis, and I am your host this week and every week. And we're here to empower you, the listener. And what we do is we provide you with legal information. This is not designed to replace the advice of an attorney. If you have a serious legal issue, go ahead and contract with an attorney. You can always find an attorney through me, or you can listen to my shows. They're all archived on my website. And nowadays, we are online on almost every single national streaming platform you can think of. You can go there to iTunes, Google Play. You can say, Alexa, play Lewis on the Law, episode 39 with attorney Lacey Bell, and voila, you will find an attorney. I've got more awesome information coming your way. When we get back, we're going to talk a little bit about contract formation.
Oh, yeah.
You are listening to Lewis on the Law. My name is James Lewis, and that music's a little groovier than I actually remembered it being. I was like, I listened to that song on my Pandora, and I was like, thought this would be great for a contract show, but it came out. But now it's called, the song is called "Bargain with the Devil," and so
it has a flow. It has a flow.
I thought, wow, that's a lot groovier than I remembered. I guess when you're working and listening to Pandora, things are not quite. I guess, am I supposed to mention Pandora on air? Who knows? I can mention Spotify because we're on Spotify. So go to Spotify. Ask for Lewis on the Law. You're listening to Lewis on the Law. My name is James Lewis. I'm here in the studio with attorney Lacey Bell, and we're here to make the law fun, interesting, and exciting. Lacey, did you know the law could be exciting, fun, and interesting?
I had no idea.
I know, right?
But it can be. It definitely can be.
It can be. And if you're listening out there and you'd like to hear a topic on to be covered on this show, go ahead and contact me on my contact page at jameslewislegal.com and drop me a line there, and let me know a little bit about the legal issue you want to hear talked about, and I will bring an attorney on who will talk about that legal issue. Now, Lacey, we're going to get into the essentials of contract formation. So what are there essentials? I mean, other than you got a piece of paper and you pay a lawyer, $5,000 to write it?
So there are, I guess what I wanted to discuss is the essentials of contracts at the time of formation, like forming your business. So
okay. Oh, there you go.
Yes,
now that
clarification.
that should really excite all the entrepreneurs out there who are listening.
Exactly. So at the time that you're forming your business, there are like I mentioned, those essential contracts that you need to absolutely have, and a lot of people try and forego them because they think it's most of the time it's because they just don't know what they need. You don't know what you need until you do, or until you talk to an attorney, which is probably, at the time of formation, an attorney would be the best person to help you obviously incorporate your business, but also help you determine what contracts you need to operate your business successfully. So those contracts that I want to talk about are partnership agreements, NDAs and confidentiality agreements, articles of incorporation, and bylaws. Believe it or not, those are contracts. Those are legally binding agreements.
You don't think of articles of incorporation as a contract or bylaws.
You don't think about it, but articles of incorporation and articles of organization, which are more what apply to LLCs or partnerships, whereas articles of incorporation are for corporations. So, but those are agreements, and those are agreements that you actually get when you license and register, or you actually submit when you register your company, and those are agreements with the state that you register with. You're saying, these are my articles. This is how my business is going to be ran. This is, if you have a CEO, these are the officers. If you don't have a CEO, then this is my business and this is the name. And different states have different requirements for what they want to see in those articles. And the last one, contract that you absolutely need, is an IP assignment agreement, especially for startups that are going to be using technology, or even brand, you're going to be creating a brand and growing it, even webs, all the way down to websites. They're subject to some copyright laws and protections. So you're going to need those IP assignment agreements and to transfer those into your company's name so that no one individual owns them. And if that individual decides to leave, they can take those rights with them.
Okay. So let's start with the partnership agreement.
Yeah.
So what kind of details do you need in the partnership agreement? I mean, isn't that back to the old spit on your palm and shake a guy's hand again?
I mean, because
I've gotten way too rustic for you, haven't I?
Yeah, the spitting is. But
it's a guy thing. You wouldn't understand.
I would not.
You're way too prim and proper to understand.
Let's just do the handshake and call it a day. But partnership agreements. So yeah, those are like the one single most important agreements if you're doing an LLC or you're coming in with a co-founder and you guys decided, in our basement, we're gonna form this awesome company and I trust this person with, everything. It's my best friends and or it's a family member or something. Stranger, non-stranger. You should have a partnership agreement.
So you should have a partnership agreement aside from the LLC that you actually submit?
Yes, you should. That's completely something different.
Not that I have a partner, but just in case I do, I need to know these things.
You do. You need to, in case you decide to bring somebody in for the fun of real estate, you should have those,
Yeah. And there's lots of fun in real estate, let me tell you what.
Well, Atlanta is the place to have that fun right now.
Yeah, exactly.
So, a partnership agreement is completely separate from your articles of incorporation or articles of organization in the case of LLCs, because it's an agreement with yourself and the members of your entity, of your business,
the people you're working with,
the people you work with, the people who started with you, the people who helped you found this brilliant, amazing company.
It's like Jobs and Woz, right?
Exactly. Those people, you trust them and everything, but you need a partnership agreement, and it's also referred to as an operating agreement. You need that to spell out how you're going to be running this business. You can't just say, well, we've been always running it this way, and then it starts to grow and starts to grow and starts to grow. You're going to need to have those terms defined in writing so that there's never any confusion or any conflict over how we're going to, have our meetings, when we're going to have our meetings, if we want to make a decision, a big decision like, buying something in the name of the company, who is going to decide that, who is going to be the person to manage the money, who's going to be the person to make those big decisions, and how we're going to do that. We're going to do a vote. You need to have all that ironed out.
Now, would that have helped? I mean, the Facebook situation with Zuckerman and his only friend at Harvard who he screwed over. What was the guy's name again?
Eduardo.
He's the only guy who was his friend, and he screws him over once they start to make money.
And they both were co-founders. And actually Eduardo was the one who put up the initial money for the company.
Yeah.
He put up like $15K.
And wasn't it his initial algorithm that started it?
Yeah. I'm not. It may have probably was, but he let Zuckerberg go and do more with it while he finished.
Because he trusted him. He was his friend.
He was his friend. And then as the company started to grow, which is what I'm talking about, it grew and they got investors involved who wanted to buy and pay. Let's just say now, and we'll talk about this later, Eduardo is a billionaire just from shares of stock.
He's doing all right.
He's doing all right.
Still, though, getting stabbed in the back by a friend of yours, it's brutal. Even if you're making lots of money, it still hurts.
It hurts. He said that he has no hard feelings. I mean, for $9 billion, I wouldn't have any hard feelings anymore. Anyway.
Once he got the check, he's like, it's all good now.
It's all it's all good. I mean, he had to go to court though, and the reason why he was able to get his $2 to $9 billion, whatever his shares are worth now, is because when Zuckerberg tried to dilute his stock or dilute his shares of interest in the company, he was able to point out that we had a partnership agreement, we had an operating agreement, and this is what I put forth, and this is what we said we were going to do, and now I'm being slowly exiled or from the company, and it's not right. So this is he went to court and got his billions.
Good for you, Eduardo.
Yeah.
You hate it for guys like that. Basically, a good guy trusting his friend, and then he gets the old knife in the back.
He gets the knife in the back. But
have a partnership agreement.
Have a partnership. Have an operating agreement. How are you going to do things? And then when your partner tries to do sneaky things, go around that by having another, creating another company to buy that company,
and somebody diluting your stocks.
Exactly. You will have recourse. You'll have legal recourse to go and say, hey, I'm owed this. So partnership agreement is a must. Next is confidentiality agreements and NDAs, and actually that goes also to that case, that famous case. They actually settled out of court because obviously it would have been very a lot of news and a lot of publicity over the details. So it's better to settle. Most companies do settle, but Eduardo had to sign a confidentiality agreement. So he couldn't talk about this, and he doesn't talk about it until like recently. I think it might have expired. So when you start a company, or when business owners start a company, they want to be sure to protect their intellectual property, or even their ideas, which also constitute the trade secrets. Like in the beginning, you might not have those intellectual property rights. Like I had a client who was seeking a patent, didn't have the patent, but had the design and had spent years like building this awesome thing. And he was trying to get like investors, and he was kind of shopping it around and talking to people. And I was like, you shouldn't be sharing, details about this or even pictures until they sign an NDA or a company non-disclosure agreement. Let me spell out what an NDA is.
Oh, yeah, that's a good one. Okay, go ahead and spell it out.
So NDA is a non-disclosure agreement, and it can be separate or a part of a confidentiality
You know what?
agreement.
We're going to have to get into NDAs in a minute. Believe it or not, we only got halfway through that segment, but we're out of time. So give them some contact. I know, it moves. Yes. Time flies when you're having fun.
It does. So I can be contacted once again at LB Legal Consulting Firm. I can be contacted at abel@lbconsulting.com.
You're listening to Lewis on the Law. This show comes to you every single week to bring you legal information. I am all about empowering you, the listener, because I understood at an early point in my life that even people who knew nothing about the law could be deeply affected by the law. So what we try and do is we try and give you legal information on what to look for, what type of things are happening, what you might want in an attorney, and maybe even who you might want in an attorney. You can always contact me to help you find an attorney. You can listen to my shows, and I give all the attorneys that appear on my show an opportunity to give you their contact information. However, whatever you do, don't take the advice of this show to be legal advice. Always consult with an attorney if you have a serious legal issue. You can give me a call at 404-610-0075. You can always email me at james@jameslewislegal.com, or you can go to my website, jameslewislegal.com, and on my last page, there's a contact page. Give me a brief description of what you need and hit send. You're listening to Lewis on the Law. When we get back, we're going to go into articles of incorporations, NDAs, IP assignments, and then business as usual. I almost feel like I should use my I want to say James Earl Jones voice, but that's because I'm a sci-fi nerd, and I know there's a cooler guy with a cooler voice. I don't know, one of those old R&B guys with a really deep voice.
Oh, yeah.
I want to use that, but I don't have it in me, I'm like, James Earl Jones, he's cool, because he was Darth Vader.
I don't watch those sci-fi movies.
I have my nerd flag just like falling out all over me. So
it's all good.
It's all good. You're listening to Lewis on the Law. I am so excited. I have attorney Lacey Bell on with me, and we are talking about one of the basic business practices you can possibly get into. We're talking about contracts. They form the basis of business. Basis, whatever, something like that. But they form the basics of business. Indeed. And so we're getting into contracts. And when we left off, we were talking NDAs.
Yes. Okay. So non-disclosure agreements, NDAs, we were talking about those, and as well as confidentiality agreements as part of the essential contracts that you need when you're forming your business initially. So as we discussed, if you have IP rights, or you're contemplating getting, patents or trademarks, before you share information about those things, and before you share information about your company, even maybe you should be having folks like investors sign those confidentiality agreements. Or even if you bring in another business partner, you should have them sign confidentiality agreements.
Now, can you do this before they're even a partner? Say say I want to talk to somebody and I've got this great idea. I don't really, because I don't have any ideas, but say if I had
I'm sure you have ideas.
Okay, but just, there you go. Give me the benefit of the doubt.
Yeah.
Say if I had an idea, I had this great idea, should I get them to sign the NDA before I even tell them the idea, before there's a partnership or anything?
Yes.
Okay.
Yes, you should. You should sign a confidentiality agreement, even if you had before you've formed your company. But since we were discussing like at the time of formation, but if you're shopping around and talking about it before you actually formed, you still should get that confidentiality agreement, because those people you don't want them to run off with your ideas. You don't want them to like go behind your back and create the next Facebook or or Instagram, and it's like, hey, that's my idea.
Pull a Zuckerman on you,
Yeah,
Zuckerberg.
exactly. You don't want them to do that, so you need to
You don't want them to Zucker you.
Don't be a Zucker. Don't be a Zucker. Don't get Zuckered, however you want to say it. Have those agreements in place and have them sign it before you discuss.
Now, can we get sued by saying that? Never mind.
Oh, man.
He's not going to do that.
No.
He's not going to care about us.
I don't think so.
Plus, other people have used his name as a bad word before, namely probably Eduardo.
Exactly. There's been worse. So those confidentiality agreements, and just to get into like a little bit of what those will give you or protections they will give you, they prevent the person you're disclosing the information to from then taking that information and using it or even repeating it to other people, so they can't discuss it with anybody else other than you. And then you can stipulate, when it ends, and, and as far as like communications, like even emails and letters that you may send back and forth from each other, you can stipulate that those should be destroyed or have to be destroyed, and they
wow, like Mission Impossible. I got more nerd flags coming out.
Yes.
So it's like destroy this letter afterwards, and it like burns up.
It burns. It should
flames.
automatically burn once you both
you
read
open it
it. It
up,
should
yeah.
automatically like just Harry Potter. That happens in Harry Potter.
It
Once
does,
you get your message,
You
from
see,
the owl.
You have a little nerd going on.
do.
There
I
you go.
have
There's a
some.
little bit there.
I have some. So you definitely want to spell out those things, and that confidentiality agreement will help you do that. So that you can keep your secrets safe. Because once it's out there, you don't get the protections of, trademark or patents. Once it's like in the public, it's up for grabs. It's in the public domain. And also you don't want people to steal it and use it.
So get those NDAs going.
Get it. Just do it. And get an attorney to do it,
Yeah.
So, and that goes right along with like IP assignment agreements and,
So what is an IP assignment agreement? I mean, we've had a couple of other guests talk about, I've had a guest talk about patents and a guy talk about intellectual property, but what is an IP assignment agreement?
So an IP assignment agreement is definitely done at the start when you create your business. Once you, like, and your partner are bringing different, knowledge into the business. So if one person was involved with creating the software, creating the algorithm, or what have you, they have the intellectual property right in the algorithm, whether it's a copyright or a patent. Those are their rights. They registered it in their name, and usually they do because this is before you have the actual company formed. So at the time that you get your company going, you need to go ahead and have those individuals sign over their rights to it, and in the company name, not to any one individual. So everybody is bringing in what they created and laying it on the table to give to the company.
To give to the company, like the company is a real person or something like
that.
The
company is a person. The company
is a person, huh?
The company is its own entity, separate from the individuals. Like, and corporations are actual entities. They're their own separate entities, and they pay taxes. LLCs don't pay taxes, but that's a whole different conversation. So you want to definitely do those IP assignment agreements. And actually, like, once you startups that have technologies and they're in Silicon Valley or whatever have you, actually Atlanta is growing for startup companies as well, and has a lot of investment firms and companies here too. So, and venture capitalists. So if
any of them invest in law firms?
No, I think we're in the wrong business.
Yeah, right.
We're in the wrong business. But once you do that, they will start looking at you. They won't actually even look at your company or give your company any funding until they've seen that those IP rights have been assigned to the company to use, exclusively. Because otherwise,
way they can come in later and steal it all, right?
It makes it much easier
if
they're in one
buyout.
place. They have to have
Exactly.
it in one place. Yeah, no. So that's exactly right.
Listeners, don't get any ideas out there.
Don't get
Okay,
any ideas.
That's bad attorney talk.
It is. But so yeah, you need to have it with the company. So the company owns it. The company has the rights to use it, not one individual. Because once you start splitting it up, that individual could take it and form their own company. And you know, it's just good business. It's good business practice, and it shows that you're actually invested in your company, giving all the rights to it.
Makes sense. So earlier you were talking something about articles of incorporation and bylaws being a contract. How does that work?
So articles of incorporation and bylaws, those are more geared toward corporations, obviously differentiated from LLCs and partnerships. Corporations have articles of incorporation that have to be filed with the Secretary of State wherever you are. And they have different things that they require in those articles. I think for Georgia, they require you to, you know, list the officers, list the, you know, corporation where the principal business office is, and also, you know, your board of directors and all that. You have to have all that lined up. So that is an agreement with kind of articles of incorporation can be seen as an agreement with the state, your state office. Bylaws are kind of agreement with the company and its business in general. Like, this is how we're going to run the company, as I said, like with operating agreements, synonymous to an operating agreement with the LLC. Bylaws say this is how much stock we're going to issue. This is the shares.
But bylaws are for corporations, whereas an operating agreement is for an LLC.
Exactly. So bylaws spell out how the board of directors, how often they're going to meet, who are the board of directors, like when we're going to issue stock, and like on what terms, and who gets to agree, and you know, and it also will say how, you know, how this stock is currently shared, like who will have how many shares at the beginning of it. So bylaws are synonymous to operating agreements that, you know, instead of, you know, the members, you'll have the corporate officers and board of directors, and how their behavior or their, you know, performance is going to be determined by the bylaws.
Oh, okay. So, are you done? Are you done with that, or
I'm done? There's so much in the bylaws, but you know, that's the overview. That's the overview. You want to like spell out how you're going to run the business, and so that when things come up, like we mentioned in the Facebook lawsuit, like when things come up, you can go back to your bylaws and say, hey, you know, I'm supposed to have this % share of the company, and I'm being diluted without my permission, you know, or by other means going and having another company buy you out. There should be.
Is that what happened in the Like, I don't know the legal details of it.
That's what happened. It was very, you know, because apparently he did have counsel advise him, you can't do this. You can't dilute his shares. And he was like, well, we can create another company and then have the company buy this company and then reissue the shares.
Oh, wow.
To the point where he was slowly, you know.
So he was actually advised that he couldn't do it, but he went ahead and
he was advised that there was. You know how, you know, as a lawyer, you can't make the business decisions for your clients, but you can advise them that this is a high risk situation. You're likely to be sued. Yeah, and that's obviously what happened.
They're just like, I'm going to do it anyways. You know, we're already at the end of this segment. Time flies when you're talking law. I know. It's so fun, so exciting. Yeah. Lacey, give them some contact information.
Yeah, so I can be reached by email at abell@lblegalconsulting.com or by phone at 678-824-4239.
You're listening to Lewis on the Law. My name is James Lewis. You can always contact me at 404-610-0075. You can email me at james@jameslewislegal.com, or you can just go to my website, jameslewislegal.com. And all my old shows are archived on my website. I think I have to update it right now, but they're all there. You can go and check out any of my old shows. You can also check out the video page, and a lot of my videos are on my video page, especially all the new generation 4K videos, because they look cool and spectacular. So they're there. And you can also find Lewis on the Law on every single major streaming service. We are even AI compatible. We've moved into the modern world. You can say, Alexa, just go find me Lewis on the Law, episode 39, with attorney Lacey Bell talking contracts, and voila, we will pop up. When we get back, we're going to talk business as usual. I want to come in and I want to say, yeah, groovy baby. something like that. But that just doesn't work for a law show. You're listening to Lewis on the Law, and my name is James Lewis, and I have lost my mind. Yes, I have. I have lost my mind, and I don't know where I put it. You're listening to Lewis on the Law. I have attorney Lacey Bell on with me, and Lacey, don't take anything that you've heard here wrong, because
I do not.
Because I just come off of a whim, and for some reason when I listened to that song earlier, I was like, the title and the idea of it's good. And I have a lot of instrumentals to play as bumper music, but that when I'm actually in the studio with headphones, I was like, wow, that's a lot groovier than I remembered it being. We're talking contracts, essential issues of contracts for business startups and entrepreneurs. And I have attorney Lacey Bell on with me. You're listening to Lewis on the Law. We have a great show going for you guys. It's exciting, it's fun, it's interesting, just the way you always knew the law could be. Now, is this all just business as usual? Is there nothing else we have to worry about? I know Eduardo got screwed over, but he had some sort of agreements that he could point to.
Yeah. So it's not all business as usual. But as we discussed, those are they're essential contracts you need at formation. And those come before you even go into business as usual, before you even start operating your company. You need those essential contracts in place. And going back to like the partnership agreements, there is the infamous case that's more recent than Facebook, the Beats headphones case.
Beats.
Yes,
yeah.
Famous
We
Dr.
love
Dre
Beats.
rapper. Yeah. So and it's similar to Facebook in that there's a founder.
Wait a minute, we've got sound dudes here. What do you guys think about the Beats headphones? They don't compete with Sennheisers and AKGs and all those German brands.
He's like shaking his head. Nope.
They say German engineering beats the West Coast. So that's serious East Coast versus West Coast.
There you go. I probably can't sue over that, but
yeah.
So the Beats headphones case was essentially an issue where a co-founder or a partner who came in with Dr. Dre and one other individual ended up exiting the company, and when he did, realized that he wasn't being paid royalties on a newer model of the Beats headphones, or a later version of the Beats headphones that he had some influence or in helping create. So he obviously was able to go to litigate and take it to court, and he actually went for, I think it was like $100 million in unpaid royalties on what his influence was on these headphones, and then ended up he wasn't successful at the trial level, and he had to appeal.
And did he get his money during appeal?
During the appeal, he got $25 million, which is
because they said there was an agreement.
They said that there was. They found evidence, and the agreement part is that there was a partnership agreement, and where he was a founder and a partner when they created these or conceptualized these headphones or these later model headphones. However, he wasn't being given the royalties on it, so it was a issue where he could point to, yeah, I was there when this happened, and I was a part of the business, and I helped in this way, and I'm not being recognized, and I'm not being paid for it, compensated.
And that's even more important. It's one thing to not be recognized, but when the dollar signs are leaving your pocket.
When the money is not adding up, that's a whole different situation.
That is a whole different situation. Okay, so now we've gotten into the business. What kind of agreements or contracts do business owners have to worry about as you're conducting business?
Yes, so once you get into business and you're operating your company on a day-to-day basis, there are very important contracts that you should have in place, like staples. And one of those are consulting service agreements. But overall, consulting service agreements, if you're running a business where you're providing a service, or you're using vendors, or you're accepting services from people, and that's probably most businesses and most companies. And then there's a standard contract form that you want to have, like for your company, if it's if it's applicable. And then
wait a minute. So companies should have a standard contract form, like
they should have a standard
just
contract
to do business,
form, and especially for small. This is more like for small companies or small businesses that, along with the consulting services agreement, where they're accepting, service from vendors or what have you, like for construction, or if they're building something, they should also have their standard contract, our operating agreement.
Like a license agreement or something like that?
Actually, so like I have a client that runs or that does a service as far as she does weddings and events and things like that, like an event planner. But what she needed and what she did not have was a standard contract that she could give to clients to say, you know, hey, this is how I run the business. This is what your fee is going to be based on these things.
Okay.
Like, and so you need to have something that spells out how you're going to be paid, when you're going to be paid, and
Got it. I've got like your standard flat fee arrangement.
Yes.
I also have a retainer agreement.
exactly.
So,
And if
yeah.
you and if we go over time, the allotted time, you know, your event is going to last this long. But if it goes over, this is my fee. And I remember having this client who would obviously like it kind of wasn't getting, you know, her dollar amount or the full value of her work, because you know, events would go over and things would happen, like with the bride or whatever it have you, and she's like over her time, but she's not getting compensated for it. Like, you should have an agreement that says, you know, if after 3 hours I'm still there and I have to be there to help you do X, Y, and Z, then it's going to cost an extra amount of money.
Yeah, you know, I'm still getting used to that, because before I became an attorney, I used to work for a certain amount per hour. And nowadays I'm billing clients at like $225 an hour, or, you know, if they don't have the right retainer, it'll be $300 an hour if I have to collect later. And I'm just like, oh, I feel so bad because I don't want to charge them for phone calls and emails.
You got to get over that feeling bad thing.
Well, the problem is if you don't, they'll call you every single day.
Exactly. You got to.
Attorney Lewis, can you please help me with this? Should I do this? And then you're like, you know what? I'm going to have to start billing you if you do that.
Because you're going to waste your time. And you're not going to be paid for your time. So, exactly. So, companies should have that. They should have a standard contract form that they're using to with all clients, and they can just hand that to them to sign, and they can see this is how we're going to be performing. This is how I need to be paid. So, if you're not using that as a business owner, you absolutely should be doing so. And an attorney can help you obviously draft that standard contract.
And then is it like a fillable PDF, or, you know, or do they just go ahead and manipulate it according to whatever the situation is?
It can be.
Or do they need an attorney to do it each and every single time?
It depends on what your business is.
Okay.
Like if your business is like, I am an event planner and these are the type of events that I do, you can definitely have a standard form that you can use, you know, over and over again. And it can be fillable to like every client. You just leave, you know, certain blanks. The attorney will leave certain blanks there that you can fill in. And corporations do the same thing. They have forms. They don't recreate the wheel every single time. They like have forms that they use and reuse, because usually when you're doing the same course of work, things don't change very often, you know.
You don't have to reinvent the wheel.
You don't have to keep reinventing the wheel. So you do that one time and you have your standard contract form, and that's business as usual. So an IP licensing form or a licensing agreement, if you have, and some startups do, trademarks, so you're going to be using your brand in some way, or you're going to let somebody else use your brand, like as like a co-sponsorship initiative or anything, then you should absolutely have like an IP licensing agreement. You should have them sign saying that, you know, this is like either a one-time use or whatever have you, or if you're giving somebody the exclusive right to use your, intellectual property, you also should be doing this licensing agreement to say, this is how you can use it, and this is where you're going to be giving me credit, and you're going to be giving me royalties based on your use of it, and money that you generate from like putting it on a T-shirt or putting my trademark on it or whatever have you, like a website, and you're generating money from it. You should be paid for the use of your intellectual property.
And I did a lot of that for the Atlanta Beltline. I used to work for the Beltline. People would want to use the Beltline and stuff, and they would just have to pay the Beltline to use their logo.
And that's the same. It's saying you and I actually, I was like right behind you.
Did you
on
work?
that. I did.
Oh, okay. Did you work for Patrice? We worked at lots of different. Okay.
Yeah, and then we ended up at the other place together too.
That we shall not name.
So yeah, but that was amazing. That was like an amazing experience, you know. So yeah, those licensing agreements, you got to have them. You can't have people around here using your brand and benefiting off of your, what they call goodwill, without being compensated for it. You absolutely should have an IP licensing agreement.
So what about the employment non-compete? We're almost running out of time, but I want to touch on this. What about the employment non-compete contracts and employment contracts? Are those things still happening today?
They are still happening, and I think with our former employer, we saw that at our former company, and that usually happens with tech companies. You know, they have competitors, so they don't want you to take the information you get there and then go and then use it to benefit their competitors. So there are some non-compete employment agreements out there. You have to decide if your business needs one, or you have to get with your attorney and decide if you need to incorporate non-competes into your employment contracts. And those are very tricky because you can't prohibit people from working. But employment contracts are definitely necessary as part of your usual course of business.
You know, Lacey, I hate to do this to you, the show. We've still got a lot to go over, but we are running out of time. Real quickly, why don't you give them some more contact information for you?
So I can be reached by my website at lblegalconsulting.com, also by email at abell@lblegalconsulting, and you can give me a ring at 678-824-4239.
You're listening to Lewis on the Law. I have had another awesome time sharing legal information with you, the listeners. And before I leave, once again, I have to thank the guys who are making the magic happen here in the studio. Let's see, the suggester of sounds, Sam Davis over there, and the venomous viper of video over there, Anthony Cook. Why all that? I don't know. I'm just coming off the top of my head. I'll see you guys next week.